Welcome to Work This Way, a labor and employment podcast. I'm Tina Emerson here in our Birmingham, Alabama office with Maynard Nexsen attorney Warren Lightfoot. Good to see you.
Hello, Tina.
Well, we have one of our own here today, another Maynard Nexsen attorney, Jennifer Wheeler. She's a skilled labor and employment lawyer with a background in business and commercial litigation. Jennifer, thank you for joining us today.
Thank you for having me.
So, Jennifer, just to kick us off today, unfortunately, terminations and layoffs happen no matter what the industry or the state of the economy. Can you share with us and with our audience the best practices for employers when reducing their workforce?
Sure, Warren. So thinking first just about layoffs, those require careful planning for the employer to think through, consider all your options first before you arrive at the decision to make a layoff. But assuming that the employer has made that decision, they'll need to first determine their selection criteria. So, seniority, performance, job classification, job knowledge, and skills of employees. The employer will want to make sure that they're avoiding any protected criteria like people who are out on leave, for example. One common misconception is that being on leave prevents someone from being included in a layoff. That's incorrect. Same thing for an employee being pregnant, for example. That does not insulate an employee from being included, but the employer won't want to use those characteristics as the reasoning for including an employee. Once the employer has determined that selection criteria, they'll want to review the employees who are included to make sure there's not an adverse impact on any protected class. So if a protected class does have a disproportionately larger percentage, for example, 75% of the included employees are women, or 75% are employees who are approaching retirement age, the employer will just want to review that list and make sure that they can defend the reasonings for including those employees in the list. The employer will be anticipating future litigation by those employees, and it's better to be able to anticipate those issues on the front end and be able to defend the decision for including those employees. And the employer may want to make changes, if it does determine that there's a disparate impact on a certain protected class.
Jennifer, let me jump in there on that just a little bit. When you are trying to make sure there's not a disparate impact, or that a certain protected category is not overrepresented in any layoff decision, I've always found it's helpful to talk to the actual managers making the decision, not sort of the overall coordinator, and try to push them on why this employee out of the department or these employees out of these departments and not others. Is that something that you use?
Yeah, I think that's right, Warren. And if there are two similarly situated employees and one of them's maybe not in that protected class, you might consider laying off the other employee, unfortunately, to help with those numbers. Different states may have different protected classes, so it's important for the employer to be cognizant of that. Some states protect, for example, employees based on marital status or whether they're a smoker. And so those are not ones we typically think of being federally protected. And so employers will just want to be aware of those. It's also important for employers to make sure that they're complying with the WARN Act, which is the Worker Adjustment and Retraining Notification Act that requires employers who are doing large-scale layoffs to notify employees who are being laid off 60 days in advance. And there's very particular ways of counting employees to determine whether the employer complies with that act. And it's important to make those determinations on the front end to make sure you give the required notice. Several states have mini WARN Acts that also have additional requirements. And so employers will want to be cognizant of whether they have employees in a state that has a mini WARN Act. Employers will want to determine whether they want to offer a severance package to the employees. These aren't required by federal law, but it can often help with employee morale and help prevent legal action in the future. It can give the employees a chance to land on their feet as opposed to just having their pay cut off, the day after they're laid off. And so employers will want to determine what sorts of benefits they're going to include with those, and typically would provide those benefits in exchange for a release against the company to where the employee would waive any future right to bring legal action.
And Jennifer, just to jump in on that, you and I have seen with several clients that we've counseled, many times a layoff is occurring because the company is either restructuring or perhaps is going through, their industry is going through an economic downturn and business is tough. But still, when you have a severance offer, even if it can be just 2 weeks of pay, that can help employees land on their feet, be more willing to engage in an agreement with the employer. And it just sort of, it can be a good thing, even when it's a small amount of money, is what we've seen.
I think that's right, Warren. There are extra requirements that the employer has to do if they are laying off people who are over 40. There's additional language that need to be included in the agreement. And if there's if there's 2 or more employees who are over 40, there's additional information that you need to give about the criteria that were utilized in choosing employees for the layoff, the eligibility factors, the ages and job titles of the various employees, and this allows the older worker to determine whether they have an age discrimination claim that they don't want to waive. Once the employer is ready to actually perform the layoff, it's important to have a smooth communication plan. And so the employer should work with HR, management, and their legal department, outside counsel, to develop a plan of how to inform both the laid off employees and the remaining employees about the layoff. It's important when you can to inform the individuals who are going to be laid off kind of in a one-on-one meeting, as opposed to them finding out, through an all-hands meeting that who is going to be laid off. So try to have those conversations individually. And then the remaining employees are going to be anxious about their own future at the company. They're going to be upset that their friends are being laid off. And so it's important to have conversation with those remaining employees about what the immediate future looks like. Don't make false promises that you can't keep, about keeping future employees around. Warren and I have seen many of our clients have to do successive layoffs. 2 months later, there's another round of layoffs. And so it's important not to give those employees false promises while also doing as much as you can to keep the morale up.
So it's really important to generate that goodwill with the employees and the employer to make sure that they have good feelings about the company and they're feeling respected when these things happen. What are some best practices for avoiding any kind of legal action or just simply protecting the company when you're terminating an employee or a group of people?
In an ideal world, you'd have, before you're deciding to terminate someone, that would be the culmination of a series of conversations with the employee, right? Particularly if you're terminating for poor performance or something like that, you've had conversations over time and there's documentation in the employee's file about the reasons. And it's very clear that now, okay, we've talked this through, it's not working out, and now it's time for your termination. Some employers think that they have to have a very specific set of documentation in the file. That's not the case. It could be emails where you're discussing this employee's poor performance, or an email to the file where you say, Sally reported that Joe, did XYZ thing today. And that documentation helps support the reasoning for termination and if you have to prove that down the road.
Jennifer, just to jump in there, we always want to be consistent and fair with our employees in every way, including those, unfortunately, that we've reached a decision that we have to terminate. And what you don't want is for the employee not to feel blindsided, right? Those are the terminations that are the worst for everyone. They're the worst for it going forward, for the potential for litigation, and to often an employee who it just didn't work out for whatever reason. So that's why we spend so much time talking about planning and about, of course, counseling and trying to get that improvement. And then if it doesn't work out, it just doesn't work out.
That's right. And sometimes the employee has done something so egregious that, you have to terminate them that afternoon or the following day, and that is what it is. And it's usually obvious when that's the case. But if it's not something so egregious like that, it is helpful to have those conversations before the fact. If there's no documentation or warnings, that doesn't mean that the employer can't proceed with the termination. So you don't have to have documentation. It just helps prove your motives for terminating later if needed. let's say you decide we want to terminate this employee. You should think about whether there's a reason that you should not move forward at that time with the termination. And so, does the employee have some potential claim that you'd like to avoid, and are there steps that you can take on the timing of the termination to help with that? So, for example, are they a member of a potential protected category, a woman, a Black person? Have they recently made a claim of a workplace hazard or complained about discrimination? Courts tend to look at sort of a 90-day time frame for those. So not to say that if you wait 90 plus 1 days, you're totally insulated from liability, but that's sort of the rule of thumb of what courts might look at. So if that employee has made a claim or complaint in the past 90 days, you might think about the timing of terminating that employee. Are they going out on protected leave the next week? That might be suspect. Make the timing of the termination suspect. It may be advisable to wait. If you've decided to move forward with the termination, check and see what rights that employee has when they're going out the door. So do they have an employment agreement that gives them certain rights? Some employment agreements entitle an employee to a severance period, for example. Determine when the employee has to be paid their final paycheck. There are some states that require the employee to be paid their final paycheck immediately. So going into a termination meeting, you'd have to have the paycheck ready to give them. Several other states require it within the next few business days. So you'll need to determine that before you have the meeting. Check your policies about payment of paid time off and vacation leave and things like that. Determine if you need to pay that out when the employee's leaving.
And hopefully your PTO policy is in compliance with the law.
Correct.
Because even though you may have a PTO rule, you may need to make sure it's up to date with your state's law.
That's right. Many states require payment of accrued PTO and some states don't, but you'd want to make sure that that's compliant. You might consider a severance package in certain instances when you're terminating an employee. If they did something very egregious, maybe you wouldn't. But, if you're just terminating a poor performer and you want to help them land on their feet, you might consider that. And then if they fall into one of those kind of protected categories that we talked about earlier, there may be good reason to provide them a little bit of payment in exchange for a waiver and release. The same best practices about the severance package would apply in this instance as well. Then you'd want to have the meeting with them in private. You'd want to make sure that there's a third-party witness in there, an HR representative ideally, or some other person of sufficient seniority or management in the company to be there. You want to keep it short and to the point. If you want to give reasoning, I recommend you give a one-liner about the reasoning and not, expound on all the various transgressions that the employee has made. Don't let them quibble with your reasoning, and don't get caught up in an argument with them about the reasoning for their termination, and don't apologize for the termination.
It's no longer a discussion at that point. The decision has been made.
That's right. You'd have, the severance paperwork, any final paycheck, et cetera, ready in that meeting. Some states require that you then notify the unemployment office. Other states allow you to wait until an employee maybe has filed for unemployment, so you'd need to check about your state's requirements for that. You'll want to turn off the employee's IT access and things like that immediately. And then tell those employees that remain about the termination. Of course, you don't want to get into confidential personnel decisions, but it's important to let those who work directly with the employee know that they're gone, that the termination was necessary, and reassure them that they can come to you with questions. It helps prevent the rumor mill that happens with terminated employees.
Jennifer, subject change a little bit, but what special, not a subject change, but different spin, what special interests come into play when an employee with remote work is involved?
A lot of the same best practices are applicable, Warren. There are some additional things, like where you're going to have a face-to-face meeting. You'll want to do that virtually on a Zoom or a Teams platform so you can see their face and it's as in person sort of as you can get rather than over the phone. employers will want to remember that they are subject to the state law where the remote worker is located. So even if you have, one remote worker who's somewhere else and you're not used to that state's laws, you need to make sure that you're complying with those state's laws with respect to this worker. You'll want to have a process to gather the employee's IT equipment, and that's a little bit more difficult when the person's, remote. So I've seen employers send, prepaid, pre-marked shipping boxes to the employee that they can put their devices in to send back. And just wanted to note something about WARN. There's a theory that WARN may not apply to truly remote workers who don't report to a physical office location, but that's kind of in flux right now. And so some courts have found that they're considered to be covered if they're receiving their assignments from a single location. And so we don't really know how that's going to play out in this new remote landscape. So where an employer is able to, it may be good for morale just to give that required advance notice where that employee would otherwise be covered.
In the event that a terminated employee just decides they do want to sue their employer, or a group of people gets together and they want to sue the employer, what is the first thing that the employer needs to do once they get that notice?
First thing they should do is contact a lawyer. And so the lawyer can help them know exactly what to do and help them develop a response strategy. It's very dependent on the venue of the complaint or the charge. Those may come into a state agency or into the EEOC, or in some instances may just be a direct lawsuit. They'll want to check whether they have insurance coverage, employment practices liability coverage, and see whether this particular claim would be covered. There are notice requirements under those policies. They'll want to preserve relevant documentation, work with their counsel to identify, what relevant data and documents need to be preserved. And that's both on the back end, like on the IT end, preserving emails and electronic files, but also on the front end. The employer will want to go to all the key witnesses and make sure that they don't have, physical documents in their possession that may be destroyed at some point. So want to retain all of those. Don't take any actions against the former employee that may be perceived as retaliation. In the case of terminated employees, that's not as big of an issue because the person's not actively working, but it may be that there's some, lingering obligations. And so the employer will want to make sure that they're not stopping any of those just because a lawsuit's been filed, since that can be perceived as retaliation. And they'll want to avoid discussing the case with the opposing party. So, many times employers will still be in contact with the former employee, and so it's best to cut off contact at that point and do all contact through the lawyers. That helps preserve your legal rights and make sure that you're not saying something that you didn't mean to that could become an admission at some point later.
And this may come into play a little bit later, but at some point, pretty soon, you always want to get into a litigation hold and document preservation issues, because that's going to be, it's going to be required most likely and is important to defend the case. So, Jennifer, what are the most common errors that you see employers making when conducting layoffs?
I think the main error that we see is boils down to poor planning and trying to rush a layoff. So, an employer might decide on a Thursday that they need to shut down a plant or a location on a Friday. That could lead to bad results because, they might use unfair selection criteria or fail to determine that adverse impact that we talked about earlier, or not have complied with the requirements of WARN. And so as far in advance as you can plan layoffs, it's best to start those conversations early. You can always plan for a layoff that never occurs, but that's better than kind of rushing one at the last minute. Obviously, sometimes things happen and layoffs need to be done quickly, but the more you can plan, the better. And I mentioned this earlier, but making promises that the employer can't keep. So telling him, the laid off employees that the employer is going to hire everybody back in 2 months, or telling the remaining employees that this will be the only layoff is a big error that employees make.
Well, this is a very timely question. At the time of this recording, President Trump was just inaugurated this week. What changes can we expect at the EEOC under this new Trump administration, and how would that impact the EEOC? How would they handle complaints of wrongful termination with these changes?
Yeah, so obviously this is in flux and could change, tomorrow. Today's January 22nd. But overall, in the Trump administration, we anticipate a shift toward more employer-friendly labor policies. And so particularly in light of last year's decision where the U.S. Supreme Court redefined the deference that's afforded to federal agencies in interpreting the laws. So right now, the EEOC has a Democratic majority, and that will continue until 2026. But yesterday, President Trump appointed a new Republican chair, Andrea Lucas, to the EEOC. And so she has had very conservative stances on employment issues. Under the Biden administration, there was sort of a broadening of rights beyond what's in the text of the existing laws. And so, as an example, the EEOC interpreted last year the Pregnant Workers Fairness Act to include accommodations for things like menopause and abortion. And Andrea Lucas spoke out against that and said she believes that employers offering abortion-related travel benefits, for example, are engaging in discrimination against other employees. She also disagreed with the EEOC's new workplace harassment guidelines, which broaden the definition of sex-based discrimination to include repeated misgendering of employees or preventing an employee from accessing a bathroom that aligns with their gender identity. She said that's an assault on women's sex-based privacy and safety at work, and she reiterated that yesterday when she was discussing her priorities for the coming term. So, that may seem like it doesn't have much effect on claims for wrongful termination, but they can have implication on those claims if, for an example, an employee is terminated after requesting accommodations for abortion care or terminated after complaining that they've been repeatedly misgendered. And the EEOC could find that those employees have no claim for retaliation because those things were not protected in the first place. And so we'll continue to monitor those changes as the EEOC issues more guidance and updates past guidance.
Well, certainly there's more of that to come. We're just a couple of days in, so we'll see. We'll watch and wait, right?
That's right.
Well, thank you so much for being here with us, Jennifer and Warren, and talking through some of these issues. They're things that employers go through every day. So thank you very much, and thank you all for watching, and we'll see you next time on Work This Way.
Unfortunately, terminations and layoff happen no matter the industry or state of the economy. Can you share with us the best practices for employers when reducing their workforce?
Sure, Warren. So thinking first about layoffs, those require very careful planning. The employer will want to determine what selection criteria they're going to utilize. For example, seniority, performance, job classification, job knowledge, and skills. The employer will want to avoid protected criteria like leave status or protected conduct. There's a common misconception that being out on leave or pregnant or something like that somehow insulates the employee from being included in a layoff. That's inaccurate. Those employees can be included in a layoff even while they're out on leave or pregnant, but that shouldn't be the reason that they're included in the layoff. The employer will want to look at the selected employees and determine if there is a disparate impact on any protected class. So is 75% of your included group female or approaching retirement age, or is every single person in your company who's out on leave included on the layoff? If there is a disproportionately large percentage in any of those specific groups, you'll want to look at those in advance and determine if the reasons for inclusion can be substantiated and what is your documentation to show that those employees were included properly.
And Jennifer, one thing that you and I like to do with our clients is to have a conversation with them about the person selected. When we see these imbalances or a greater number of a certain protected category or something that concerns us, it's often helpful not just to talk to the coordinator of this big layoff. It could be actually talking to the supervisor themselves in each of the discrete departments and having them actually explain why they chose one employee over another. I think that's often a way to sort of dig down to try to get it right.
That's right, Warren. And at some point, the employer may have to provide evidence to substantiate why they picked each employee. And so it can be helpful to look at that in advance and be able to, make notes about their reasoning at that point. And if there's two similarly situated employees, one who's in the protected class and one who's not, and you are finding that disparate impact, sometimes you may have to choose the employee who's not in the protected class just to sort of help that impact level out better. Different states, have different protected classes. So the employer will want to make sure that they're looking at the states that apply and include, sorry, can I go back on that or is, okay. Different states may have additional protected classes. So the employer will want to look at the states that apply to the layoff and make sure that they're accounting for those protected classes as well. For example, there are states that protect against an employee's marital status or whether they're a smoker. And so those are not what we typically think of as protected classes. And so the employer will want to be careful to consider all of those as well.